The legal framework in India is continually evolving to address new challenges, protect rights, and ensure justice. The recent enactments in criminal law are a testament to this dynamic process. As educators, it is our responsibility to stay abreast of these changes, understand their implications, and effectively communicate them to our students and the wider community. This program brings together esteemed legal experts, distinguished scholars, and experienced practitioners who will provide in depth insights into the new criminal laws, their background, their impact on the legal system, and their broader social implications. Through a series of lectures, case studies, and interactive sessions, we aim to foster a comprehensive understanding of these critical legal developments. Over the next few days, you will have the opportunity to delve into various aspects of new laws, engage in meaningful discussions, and develop innovative teaching strategies. We encourage you to take full advantage of this opportunity to enhance your legal acumen, collaborate with your peers, and contribute to the ongoing discourse on criminal justice reform in India. I would like to express my gratitude to our distinguished speakers and facilitators for their invaluable contribution to this program. Your expertise and dedication are instrumental in making this initiative a success. It's our privilege to have with us today's speaker, Sri D.R. Venkatasudarshan sir, retired principal, district and session judge, who has graciously accepted our invitation to address us today. Sir, we are deeply honored by your presence and expertise. Sir will be enlightening us with his vast knowledge and experience on the topic, an overview of Bharatiya Nyaya Sanhita 2023. We are eager to benefit from his insights and perspectives on this significant subject. A warm welcome to you, sir. To all participants, your presence here reflects your commitment to professional growth and excellence in legal education. Let us approach this program with an open mind, a spirit of inquiry, and a dedication to advancing our understanding of criminal law. To ensure a smooth and successful event, participants are requested to kindly adhere to the following essential guidelines, which I already posted in the group. Participants are required to attend all the scheduled sessions and actively engage in discussions and activities. Full participation is essential for a holistic learning experience and for issuing certificate. The session link remains the same for all 7 days of the program. Please log in on time for each sessions, preferably 10 minutes before the session, that is by 4:50 p.m. You are encouraged to post your queries relating to the topic in the chat box, which will be addressed by the speaker at the end of the session. Kindly provide constructive feedback on the sessions and the overall program. By adhering to these rules, we can create a productive, respectful, and engaging learning environment for everyone involved. Your cooperation is greatly appreciated. Let us embark on this journey of knowledge and growth together. Thank you for being a part of this program. I wish you a productive and enriching learning experience. With these words, I officially declare the online faculty development program on newly enacted criminal laws in India open. Let us embark on this journey of knowledge and growth together. May I now request our principal, Dr. K.B. Kempegowda sir, to formally welcome the gathering and share his valuable thoughts with us.
Thank you, Nirmala. Good evening. The respected the chairman of our governing council, Shri Lakshmi Manohar, today's distinguished speaker, Dr. Venkatasudarshan sir, colleagues, participants from various law schools. I deem it's my privilege to welcome each one of you to this faculty development program organized by Janata Education Society's Vivekananda College of Law, Bangalore. And at the outset, let me thank each one of you for constantly supporting in all our endeavors in joining these faculty development programs, which is mutually beneficial to all of us. Today we have amidst us Shri M.R. Lakshmi Manohar, the chairman of our governing council, who is the man who always supports in all our activities in organizing program. Sir, I take pleasure to welcome you on this occasion. We have today dear Venkatasudarshan sir, former district and session judge, to deliberate upon an important subject, that is an overview of the Bharatiya Nyaya Sanhita 2023. Sir is always supporting us in all our activities, and it's my pleasure to give a brief profile to you all. Dear Venkatasudarshan sir, after obtaining his LLB degree in 1978, joined judicial service in 1987, and in the year 1987, he was joined judiciary as a judicial officer and worked in different capacities at different places in the state of Karnataka, and retired from service on 30 district and session judge. After his retirement, he was appointed as the president of Consumer Disputes Resolution Forum and served in Shivamogga and Bangalore for 2 terms. Sir has did his LLM in the year 2011 and obtained his LLM degree in 2013. Sir has always associated with the Karnataka Judicial Academy, which is a prestigious institution in training judges and lawyers. He associated with Judicial Academy and other law schools from the beginning as a resource person. He is a most sought after resource person, not only in the Judicial Academy, even in law schools also. Sir, we are very much blessed by your presence, and I, on behalf of Janata Education Society's Vivekananda College of Law, extend a very warm welcome to you, sir. Sir, welcome.
Thank you, Principal Sir, for your warm welcome.
Yes, we have amidst us our Chairman, Governing Council. May I now request our Chairman, Governing Council to deliver a brief inaugural speech. Sir, over to you, Lakshmi Manohar sir.
Sir, your mic is mute, sir. Lakshmi Manohar sir, please unmute the mic. Yes, sir.
I heartily welcome you, all dear participants. At the outset, I congratulate you all for registering in this 7-day faculty development program, which testifies your commitment to learn and update yourself. Teachers are perennial students, meaning which teachers are expected to be students forever as long as they are teachers. Learning is an ongoing process which is eternal. Unless a teacher is willing to learn, cannot be a good teacher. Our FDP step in this direction of supporting them in the learning process. The aim of our faculty development program is to foster continuous growth and excellence among the teachers. The motto of our FDP is not only to enhance the professional skills of the teachers, but also to act as catalyst for growth and success of the students. Teachers should imbibe the culture of continuous learning that benefits both the teachers and students, which can translate into more effective learning by the students. Faculty development program are integral to growth and success of teachers, promoting excellence in teaching and research, and also prepare them with latest teaching methods. This continuous growth enables the teachers to keep pace with the ever-changing demands of modern education. The current scenario demands adaptive and innovative teaching pedagogies to help students reach their full potential. The FDP allows the participant the luxury of directly interacting with the experts in the field. I hope the 7 days of learning in this FDP will translate you into better teaching skills. make the most of this opportunity, as we have invited the best minds in the industry and the fraternity to be the resource person. All the best, all the very best. Thank you.
Thank you, sir, for your insightful inaugural address. Your words have set the tone for an enriching and enlightening experience. Let us now begin our faculty development program, enriched by the presence and contribution of our distinguished guests and participants. I request the respected speaker to start the session. Over to you, sir.
Bonnet, pin him, sir, please.
Am I audible?
Yes, sir.
Yeah.
Yes, sir.
Am I audible?
Yes, sir.
Okay, thank you, madam. Thank you. Ellariggu namaskara. Very fine. Good evening to one and all.
Good evening, sir.
Respected Chairman of the Governing Council of the Janata Education Society, Shri Lakshmi Manohar sir. The respected Principal of the Vivekananda Law College, Dr. K.B. Kempegoda. The Faculty Coordinator, Srimati Nirmala P. Hegde. And Coordinator, Dr. Bhuvneshwari S.K. And also all the very highly distinguished, enlightened, educated, and elite persons who are in the who are watching this program online. I don't know to what extent I can reach up to your expectation, because you are all academicians and you will be knowing better than what I know. I always hope so. But anyway, since I have been entrusted with the responsibility by the respected principal, I have to discharge my part of duty to the best of my ability, and I hope to your satisfaction. At the outset, I sincerely thank Dr. K.B. Kempegoda sir for providing me this opportunity of being online with you in this beautiful evening to share my few thoughts on the new branch of criminal law which has come into force from 1/7/2024, that is Bharatiya Nyaya Sanhita 2023, which has replaced the Indian Penal Code. Really, it's a very good program that has been arranged, faculty development program, because as learned Chairman sir has said, we are all in the process of learning and we are students forever. A judge, a lawyer, and an academician, we are all students forever. There is no end for learning at all. So I am also a student like you who is studying simultaneously with you and trying to understand the things in a better manner. With this humble note, I would like to start the discussion on this subject. The subject is very vast. It may not be possible for me to tell the entire overview of 358 sections over a period of 1.5 hours. Therefore, I have requested the principal also on this aspect. Therefore, I will be covering only the introductory part and mainly also concentrating on few important newly added sections like organized crime, petty organized crime, mob lynching, Deshodroha, and snatching. After giving a brief introduction of the subject, I think that will take care of the 1.5 hour time that has been allotted to me, and I doubt even that would be sufficient or not. So if you permit me, I will extend further. Otherwise, I will stop exactly after 1.5 hours. Indian Penal Code, as we all know, was enacted in the year 1860 by the British Parliament. It has ruled the country almost for about 164 years, 163 years. A wonderful piece of legislation covering all types of offenses which a human being can commit. And it is so important to say that, and the act is so important and so vital that we could not amend even a single section, except that we could add some more sections to the provisions which are already there. But now there is a need for bringing a new law. Where was the need? A question would arise. The object behind the introduction of the new law is because the government considered it expedient and necessary to review the existing criminal law with an aim to strengthen law and order and also focus on simplifying the legal procedure so that the ease of living is ensured to the common man. So a common man is at the center. In order to make the common man to understand and to come out of this legal complications or difficulties in legal proceedings, in order to make an ease of living for him, the parliamentarians have thought that there is a need for change of this.
Sir, can you unmute, please? Your mic is mute, sir. Sorry, sir, for the disturbance.
Yes, now
Yes, sir. Yes, sir. You are audible, sir.
Bharatiya Nyaya Sanhita, which has replaced the Criminal Procedure Code. Bharatiya Nyaya Sanhita 2023, which has replaced the Indian Penal Code. And Bharatiya Sakshi Adhiniyama, which has replaced the Indian Evidence Act. And the overview of this act can be summarized in brief as under. The Sanhita gives precedence to offences against women and children, and also to the offences of murder and offences against the state. Some of the offences have been made gender neutral. In order to deal effectively with the problem of organized crimes and terrorist activities, new offences of terrorist acts and organized crimes have been included with deterrent punishment. In new offences on the act of armed rebellion, subversive activities, separatist activities, or endangering the sovereignty or unity and integrity of India has also been added. The fines and punishments for various offences have also been suitably enhanced. And for the first time, community service has been included as one of the mode of punishment. So these are some of the important aspects that could be kept in mind when we are reading the Bharatiya Nyaya Sanhita. The Indian Penal Code 1960 had 511 sections spread over 23 chapters. That is now repealed by Bharatiya Nyaya Sanhita 2023, which has only 358 sections spread over 20 chapters. Then a question may arise. Does it mean that section 511 to minus 350, whatever the balance is there, that has been removed? Certainly not. They have been retained and some more sections have been added, which one can come to know if you have a deep look into the subject and read it. That we will see how the new statute has taken a shape. As all of us know, and particularly the academicians are very well aware of the fact that before we want to read any enactment, we have to read the preamble portion and the definition portion. The reason being, the preamble portion tells you about the scope, object, and purpose for which the act has been enacted, and also specifies the methodology in which the act is going to follow in order to achieve this object. The definition clause in every enactment is useful for the simple reason that certain words and phrases which are used in that particular enactment will have to be understood in the same manner as has been defined in the definition clause. And the definition clause is of great significance sometimes because that will have a very wide impact on the whole enactment itself. This is also another important aspect that has to be kept in mind that we will see in the course of the discussion. Now, the Bharatiya Nyaya Sanhita, as compared to Indian Penal Code, has been made more easy, convenient, and and very easy to make a reference to any particular section. Why I am telling this is, the sections have been organized in such a way that when you want to see whether a particular act comes within a particular heading or some other heading, you can straight away go to that particular chapter and find out the relevant section. But in the Indian Penal Code, it was not like that. In the Indian Penal Code, there was different sections pertaining to a different type of a different category of offences spread over on different chapters. But in Bharatiya Nyaya Sanhita, it is not like that. All those offences which are coming under one category have been brought under one chapter under different parts, and so that the reference will be very easy, very quick, and you can straight away go to the particular section and understand it without taking trouble of searching here and there. This is one important advantage that you have while reading Bharatiya Nyaya Sanhita over Indian Penal Code. The another important thing or change that you can notice, very important thing change that you can notice is, in Indian Penal Code, in the form of general explanations, you find from section 6 to section 52A, which can otherwise be called as definitions. All these 46 or 47 sections have been brought under one heading, that is under the definition class, from section 2, subsection 1 to subsection 39. So whatever the definition, whatever the words and phrases that you had from section 6 to section 52A of the Indian Penal Code, you will find them in one section, that is in section 2, in the form of subsection 1 to section 39. So this is another important change that has taken place. Why I am telling this is, and that has been arranged in an alphabetical order, as in any other enactment it is being done. So far as the definitions are concerned, thereby it will be very easy for us to make a quick reference and save over time. This is another important advantage in the BNS that you find. Now, first let us go to the definition class and its importance. I told already that though in the definition class the amendment is very, very small, but its impact is very big. How? We will see. Section 2, subsection 3. I'm not taking you through all the definitions. I'm only taking you through certain definitions which I feel important. Section 2, subsection 3 of the BNS means Bharatiya Nyaya Sanhita, is a new clause which has been inserted, which was not there in the Indian Penal Code. What does it say? According to this clause, they define the word child. Child means any person below the age of 18 years. You may ask what is special about it. It has got a very huge impact. If you go through the provisions of the Indian Penal Code, I draw your attention to section 363A. Of the Indian Penal Code. How this definition is important and what sort of significance it has, you can very well make out. If you go to section 363A, It defines sorry, 361. 361A, 361. It defines kidnapping from lawful guardianship. Am I audible? Am I audible?
Yes, sir. Yes, sir.
Yes. Kidnapping from lawful guardianship. Whoever takes or entices any minor, please underline the word minor, under 16 years of age, if a male, or under 18 years of age, if a female, or any person of unsound mind, out of the keeping of the lawful guardian of such minor, or person of unsound mind, without the consent of such guardian, is said to kidnap such minor. So what is the punishment? All those things are prescribed there. Now here, if you go to subsection 363A, subsection 3, subsection 4, clause B, you find minor has been defined in case of a male, a person under the age of 16 years, and in case of a female, a person under 18 years of age. Please keep this in your mind. In section 363A, as I have already said, which speaks of kidnapping or maiming of a minor for the purpose of begging, subsection 1 says, whoever kidnaps any minor, kindly underline the word minor, or not being a lawful guardian of a minor, obtains custody of a minor in order that such minor may be employed or used for the purpose of begging, shall be punished with an imprisonment, etc., etc., etc. Now, under the Indian Penal Code, the word used is minor, not child. So, and section 363A subsection 4, clause B, defines who a minor is according to this particular chapter. According to this particular chapter, a male person is said to be a minor who has not attained the age of 16 years. So, what should happen to a person who is 16 years and above 18 years, if he is not a minor according to this particular subclass? So, he cannot be said to be a minor. But under all other enactment, we find that up to 18 years, even including Indian Majority Act, a person who has not attained the age of, who has attained the age of 18 years is a major. So, a person who has not attained the age of 18 years is a minor. So, if a boy who is aged more than 16 years and less than 18 years, he is not considered as a minor for the purpose of these sections under the Indian Penal Code. Now, come to the Bharatiya Nyaya Sanhita. Bharatiya Nyaya Sanhita has defined the word child. And wherever the word minor is found in the Indian Penal Code, it is replaced with the word child in BNS. So the consequence of this is, even a boy who is more than 16 years and under the age of 18 years, if he is kidnapped from a lawful guardianship, or if he is taken by a person who is not a lawful guardian, he is said to have committed an offense as mentioned in section 361, 363A, etc. So this is the significance of this particular definition. So wherever the word minor is used in Indian Penal Code, it is substituted with the word child, which means even a male person who is above the age of 16 years, under the age of 18 years, is covered under the particular topic. So that's why I told in the beginning itself that though the amendment is very small, it has got a very big impact when you read the remaining sections of the Bharatiya Nyaya Sanhita in this context. Then the other important definition is, in Indian Penal Code, the word court of justice was being used in section 20 of the Indian Penal Code. That has been now removed, and in its place only the word court is used. And another important definition is, a word document has been defined in section 29 of the Indian Penal Code, which you find same in section 2, subsection 8, with an addition, document includes electronic and digital records. So in addition to the definition of the word document found in the Indian Penal Code, which has been reproduced in Bharatiya Nyaya Sanhita, the additional word includes electronic and digital records as documents should be read. What is electronic record? What is digital record? That has been defined in the Criminal Procedure Code and also in the Indian Information Technology Act. Then, coming to the word gender. This is also an important and a new addition it is. In Indian Penal Code, gender was referring only to a man and a woman, a male and a female. But under the BNS, that is Bharatiya Nyaya Sanhita, gender includes a transgender also. So for the first time in the Indian Penal Code, a transgender has also been brought under the definition of a gender. And an explanation has been added to that transgender definition, wherein it is stated, a transgender means a person who has been defined so as a transgender under the Transgender Persons Protection of Rights Act of 2019. What is that definition? In Transgender Protection of Rights Act of 2019. For the benefit of all, I have called out the definition also, which I am now reading it. Section 2K of the Transgender Persons Protection of Rights Act of 2019 defines transgender person means a person whose gender does not match with the gender assigned to that person at the time of birth and includes trans man, trans woman, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy or such other therapy. Person with intersex variations, gender queer, and persons having such socio-cultural identities as Kinnar, Hijra, Arwani, and Jagta. So they are the persons who can be who are categorized as gender persons, as transgender persons. So here under Bharatiya Nyaya Sanhita, subsection 2 of section 10 includes a transgender also in the definition of a word gender. And all other words like British Parliament, Crown, Queen, and English Gazette, all those words which are found in Indian Penal Code have been removed because now the nativity of the thing has been Bharatiya has been added there. So all those words have been removed and it has been made strictly Bharatiya, having a smell of Bharatiya culture. And that is another thing that you can find in this particular definition class. And so far as the word public servant is concerned, section 21 of the Indian Penal Code defines who a public servant is. The equivalent is section 2, subsection 28 of the BNS, where in addition to the definition which was already there and which has been reincorporated into the BNS, there is one more word that is used. Every assessor or member of a panchayat assisting a court or a public servant is also a public servant. So these are some of the important changes in the definition column. I told you already that the definitions of the words used in the Indian Penal Code were in the form of general explanations from section 6 to section 52A, and all those things have been puffed into one section, that is section 2, from sections 2, subsection 1 to section 39. Then so far as the chapter 3 is concerned, that is of punishments. Section 53A of the Indian Penal Code provides for 5 different modes of punishments. One is death sentence, life imprisonment, simple imprisonment or rigorous imprisonment, forfeiture of property, and fine. Now one more mode of punishment has been added, to that particular section as community service. What is community service has not been defined in the Indian Penal Code. But by way of explanation to section 23 of Bharatiya Nyaya Sanhita 2023, community service has been defined as to mean the work which the court may order the convict to perform the form of punishment that benefits the community, for which he shall not be entitled for any remuneration. It is needless to say that the question of punishment arises, imposing punishment arises only when a person is found guilty of the offense and only when he has been convicted. So under such circumstances, the court may, instead of sentencing him to any term of imprisonment or payment of fine, may direct him to undergo community service, perform community service. What is community service? Two essential aspects are to be noted. To constitute a particular service as a community service, there must be two essential components. Number one, the person must have been convicted. Number two, he is liable to be sentenced with such imprisonment and fine as provided in the relevant section. And number three, the service that is ordered to be performed must benefit the community as a whole. It should benefit the community. And number four, he is not entitled for any remuneration. So this is a new sort of punishment that has been added in BNS in the form of a community service. Then a question may arise: what are such type of services which could be called as community service? Some of the raw examples which can be given, according to me, that strike to my mind, is asking the convict to render a free labor for public works, like cleaning the public parks, cleaning the public playgrounds, rendering service in the hospitals, government hospitals, rendering service in a recognized charitable institutions, or any other society-oriented activities. Those are the types of punishments that can be called as community service, according to me. However, we have to wait and see as to how the law develops in the days to come to include the other categories of services also as community service. So far as Chapter 4 of the Indian Penal Code, that is general exceptions, which are found in Chapter 3, is concerned, there is no change, and whatever was there in the Indian Penal Code, it has been incorporated into BNS. So far as Chapter 5 and 5A of the Indian Penal Code is concerned, which deals with abetment, criminal conspiracy, and attempt to commit offense. Also, there is no change. Except a small change in the form of Section 48. Abetment outside India for offences in India. That is, a person abets an offence within the meaning of the Sanhita, who without and beyond India abets the commission of any act in India which would constitute an offence within India. Except the small change, addition, there is no other change. And one more important aspect that has to be considered while reading this particular chapter is that in the Indian Penal Code, you find an attempt to commit an offence at Section 500 in Section 511. That is the last section in the Indian Penal Code. An attempt to commit an offence is also an offence. But that has been now brought in the Indian Penal Code as Section 62 of the BNS. So 511 of the Indian Penal Code is now Section 62 of the BNS. This is another important thing that you find in this BNS. Then coming to Chapter 5. Chapter 5 is a very important section according to me in the Indian Penal, in the BNS, in the Bharatiya Nyaya Sanhita, because it deals with the offences against woman and child. This is from section 63 to section 99 of the BNS. This has got 5 parts. Number 1, of sexual offences, section 63 to section 73, of criminal force and assault against a woman, section 74 to section 79, of offences relating to marriage, section 80 to section 87, of causing miscarriage, section 80 to section 92, of offences against a child, section 93 to 99. So, all those offences which were spread over in different chapters of the Indian Penal Code relating to the offences against women and child have been brought here together and grouped. Thereby, it gives a very easy and convenient way of reference to any section while reading the offences said to have been committed. Now, let us see first section 63, what changes have taken place. I am only mentioning the changes because I have no time to go through all the relevant portions in the section. Section 63 deals with rape. And equivalent section is section 375 IPC. One of the important change that has been brought about in this section, in this chapter rather, in this offences relating to rape, is at the end of exception 2, to section 64 of the BNS, which is equivalent to section 375 of the, section 63 of the BNS, which is equivalent to section 375 of the Indian Penal Code. I hope all of you are having a book in your hand. If you go to section 63 of the BNS, Bharatiya Nyaya Sanhita, where you find the definition of rape. In exception 2, that is after 6 circumstances which can be considered as rape, there is explanation and exception. Provided that this is proviso of the explanation 2. Provided that a woman does not physically resist to the act, then bekilla namge. Exception 1 bekilla. Exception 2. Sexual intercourse or sexual act by a man with years. This is actually 18 years is a newly added term. Earlier it was 15 years. In the Indian Penal Code as amended, it was 15 years. It was reading like this: sexual intercourse or a sexual act by a man with his own wife, the wife not being under the age of 15 years was the earlier found in Indian Penal Code by way of exception 2. Now that has been made as 18 years. This is very important aspect. That's why I'm discussing about it. if you retain that 15 years as it is, what would have been the consequence? According to me, my limited knowledge and understanding, I am explaining. If I am wrong, I will be very happy if someone can correct me. We all know that the age limit for eligibility of the marriage is 18 years in case of a female and 21 years in case of a male. We also know that there is one enactment called as Prohibition of Child Marriage Act. So if a female is under the age of 18 years and if she gets married, that becomes a child marriage. That is prohibited under the act. More so in Karnataka, by virtue of an amendment, such marriages have been declared as void marriages. So they have no existence in the eye of law at all. Please keep this in the background. If you keep this in the background and read the old IPC, where it says that any sexual intercourse with a man on his own wife, with his own wife, and wife not being under the age of 15 years, means what? So if a wife is aged more than 15 years, and less than 18 years, and if any sexual act is committed on her by her own husband, that will not become a rape. Will it not run inconsistent with the provisions of the Child Marriage Prohibition Act? Because after 15 years, up to 18 years, she is a minor only. She is a child only. Therefore, in order to bring this in pari materia with that particular provision under the Child Marriage Act, according to my limited knowledge, this 15 years, which was found earlier in the Indian Penal Code, has been taken away, and now in its place, 18 years has been added. This is one important aspect that has to be kept in mind when we are reading the Bharatiya Nyaya Sanhita section 63 along with section 375 of the Indian Penal Code. In this chapter relating to rape, one new section has been added. That is in the form of section 69. There were a lot of debates or discussions going on among the members of the legal fraternity that what would happen if a person promises to marry a girl and have a physical contact with her, and later if it doesn't marry, what will be the consequence? There were a number of judgments on that. Let us not discuss upon that because of the paucity of time. So in order to overcome, according to me, such a situation, section 69 of the BNS has been brought into the statute book. A similar section to this was not there in the Indian Penal Code. So this is a new section. What does this section say? Section 69 reads, sexual intercourse by employing deceitful means, etc. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same, please underline that, without any intention of fulfilling the same, has sexual intercourse with her, such sexual intercourse not amounting to the offence of rape shall be punished with an imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. This is actually, according to me, a very revolutionary section that has been introduced in order to teach a lesson to such persons who practice a deceitful attitude towards women. What does this section say? This section says that whoever promises a girl that he would marry her, but in his heart of hearts, he will never have an intention to marry her. That is called as deceit. Having something in mind, doing some other thing is a deceitful attitude. So he really doesn't want to marry her. He doesn't have an intention to marry her, but promises to marry her only with the purpose of having physical contact with her. Look at this section. Whoever, by deceitful means or by making promise to marry to a woman, without any intention of fulfilling the same, has sexual intercourse with her, and that is not a rape because she would have consented. She would have consented because he had promised to marry her. So because of the promise that that this man has made, she has consented, and therefore he committed rape on he had a sexual intercourse with her, a physical contact with her. That does not amount to rape. Still, because of the deceitful attitude of that particular person, by giving a promise without having an intention to fulfill that promise, that becomes an offense under section 69, for which the punishment has been fixed at 10 years, which may extend up to 10 years and shall also be liable to fine. So this is a new section that has been added to this particular part in this particular chapter of offenses against women. Except this, there is no other change that has been brought so far as under this heading of sexual offences, that is from section 375 to section 376E to 376A to E of the Indian Penal Code, which is from section 64 to section 73 of BNS. There is one more type of offence against a woman, that is outraging the modesty of a woman, which is under section 354 of the Indian Penal Code, and equivalent of this is section 74 of the BNS. When I was talking about the overview of the Bharatiya Nyaya Sanhita, I made a mention that one of the aspects that has been introduced in BNS is that some offences have been made gender neutral. That is, though the offence is committed against a woman, whether offence is committed by whether such offence is committed by a man or a woman, they are equally punishable. Which are those sections? In section 354 IPC, section 350, section 354B and section 354C were not gender neutral. They were applying only when an offence is committed by a man against a woman. But in the equivalent provisions in BNS, that is section 76 and 77, says, assault or use of criminal force to a woman with intent to disrobe. Whoever assaults or uses criminal force to any woman. So it says whoever. But whereas in section 354, corresponding section, it was there as when a man. So in place of that, whoever has been brought, that is, it has been made gender neutral. And similarly, section 354C, voyeurism. Voyeurism has also been made gender neutral in section 77 by saying whoever watches or captures the image of a woman engaging in a private act in circumstances, etc., etc., etc. So it is in this way that some of the offences which were earlier not gender neutral have been made gender neutral under BNS. So except this, there is no other amendment or change in this particular topic of offences against women and criminal force and assault against women, that is from section 74 to 79. And also of offences relating to marriage. And under offences relating to marriage, of course, I have got to say something here. With relation to the offences relating to the marriage is concerned, We are all aware that Section 498A of the Indian Penal Code, which deals with the cruelty against a woman, provides that whoever being a husband or his relative subjects a woman to cruelty, he shall be punished with an imprisonment which may extend to 3 years and also fine. The word cruelty has been defined by way of explanation to Section 498A, Explanation 1 and Explanation 2. Explanation 1 was dealing with physical cruelty. Explanation 2 was dealing with dowry, cruelty demanding dowry, in connection with the demand made for dowry. Now, the change that has been brought in BNS is 498A has been retained as it is. There is no change. 490 explanation also has been retained as it is. But only thing is, the section part has been given a separate number as section 85, and explanation part has been given a separate number as section 86. Except this, there is no other change. In relation to the offences against a child is concerned, which is from section 317, which is under section 317, 318, 366A, 369, 372, and 373 of the Indian Penal Code. Now you find those sections grouped under section 93 to section 99 of the BNS. That is Bharatiya Nyaya Sanhita. In section 93, there is no change. Section 94, there is no change. But section 95, a new section has been added in BNS. What is that new section? Section 95 reads like this: hiring, employing, or engaging a child to commit an offense. Section 95 I am reading of BNS. Whoever hires, employs, or engages any child to commit an offense shall be punished with imprisonment of either description, which shall not be less than 3 years, but which may extend to 10 years, and with fine. Let us stop there for a minute. What does it mean? It means, supposing a person hires a child, I have already said, any person who is under the age of 18 years. Whoever hires or employs any child or engages any child to commit an offense, shall be punishable. Supposing, let us say, for example, X hires a child. His intention is to employ that child for the purpose of committing an offense, maybe for begging, maybe for prostitution, or maybe for other bonded labor, whatever it is. So he engages it for the purpose of committing an offense. All these are offenses. So if he hires or engages a child or employs a child only with an intention that through that child an offense will have to be committed, then such person is punishable with an imprisonment which may extend up to 10 years and with fine. It doesn't stop there. And if the offense be committed, shall also be punished with the punishment provided for that offense if the offense has been committed by such person. Supposing X employs a child A for the purpose of committing an offense, that itself is an offense. Whether the child commits an offense or not, that's a different matter. The very intention behind hiring a child or engaging a child or employing a child by a person is only to commit an offense. So that intention itself is punishable with an imprisonment which may extend up to 10 years. Supposing the child is actually employed in the commission of an offense, for example, begging, prostitution, whatever it is employed, then whatever the punishment is prescribed for that particular act, that is actually putting the child into an employment of doing an illegal act, whatever the punishment is prescribed, even that punishment also should be inflicted on X in addition to this. This is a new section that has been introduced in BNS. Therefore, it is very important, especially nowadays. Then, the another important amendment that has been brought is to Section 304A of the Indian Penal Code, which is in the form of Section 106 BNS. Section 304A IPC provides that whoever by his rash and negligent act causes death of a person, he shall be punished with an imprisonment which may extend up to 2 years and fine. Now, that is changed. It is altered to say that whoever causes death of a person on account of his negligent act, such person is punishable with an imprisonment which may extend up to 5 years, as against 2 years which was there earlier, and also fine. So what is the consequence of this? By increasing the punishment from 2 to 5 years, one of the important consequences, Section 304A was triable as a summons trial case. CRPC, that is BNSS, defines a summons case is one where the offense is punishable up to 2 years of imprisonment. So earlier 304A was triable by a magistrate as a summons case. But now, since 2 years has been enhanced to 5 years, it becomes a warrant trial procedure. So there is a slight change in the procedure also. That is one thing. There is an exception to this. Exception means there is a sentence-wise some modification has been made. A liberality has been shown here. What does it mean? Newly added. And if the act is done by a registered medical practitioner, while performing a medical procedure, he shall be punished with an imprisonment which may extend to 2 years and shall also be liable to fine. If a person was driving a vehicle on a public road in a rash and negligent manner and causes death of a person, the punishment prescribed is up to 5 years and fine. But if if on account of such rash or negligent act, if the death is caused when such act is committed by a registered medical practitioner during medical process, then punishment is not 5 years, it is only up to 2 years. Supposing a doctor conducting an operation has negligently did something which has resulted in the death of a person, then that is not punishable with so much of severity as in the case of a person who drives a vehicle and causes death. It is with a lesser punishment of 2 years. So therefore, this is another important aspect that has to be noted when we are talking about Section 106 of the BNS. And who is a registered medical practitioner for the purpose of this section has also been defined in the form of an explanation. For the purpose of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification registered under the National Medical Commission Act of 2019 and whose name has been entered in the National Medical Register or State Medical Register under the Act. So he is the registered medical practitioner, and this particular concession of 2 years instead of 5 years is applicable only to such registered medical practitioner who come under this explanation, and that too when such a death is caused when that registered medical practitioner is conducting a medical procedure. Then one more amendment has been brought here. We have seen number of cases where, especially every day we will be reading in newspapers almost, where a person would have driven the vehicle in a high speed on a public road in a rash and negligent manner, dashes against a person, and he doesn't stop the vehicle, he goes away. We do not know where he goes, who he is, and what is the vehicle number. That is a hit and run case. In such cases, the investigation will be very difficult. So therefore, in order to put a control or a restriction on such offences, a new subsection has been added to section 106 BNS, which says, whoever causes death of any person by rash and negligent driving of the vehicle, not amounting to culpable homicide, and escapes without reporting to a police officer or a magistrate soon after the incident, shall be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. Supposing a person drives a vehicle in a high speed and in a rash and negligent manner on a public road, causes an accident resulting in death of a person, the duty cast on the driver is to go to the nearest police station or to inform the police station at least over phone about the mishap that has taken place. Or if not, he should go to the magistrate and report the incident. If he doesn't do either of these two things and runs away from the place, escapes from the place, then the punishment that is prescribed for such person may extend up to 10 years. This is another addition that has been made to section 106 of the Indian BNS. So I think with this I will stop the main part of the the relevant sections which I wanted to deal with. And sir, Mr. Kempegowda, sir.
Sir, please, sir.
Shall I proceed with organized crime?
Please, sir. Please, sir. Please, sir. Please continue.
Thank you.
Right.
Now, in the same chapter where you find section 107, you have three more important sections: organized crime, petty organized crime, terrorist act. And in addition to this, I will also be, if time permits, discussing about mob lynching and snatching and Deshadroha. With regard to the insertion of this new section, that is petty organized crime, the Parliamentary Standing Committee on Home Affairs, in its 246th report, in clause number 109, observes like this, quote, the committee observes that the existing laws were inadequate to tackle the menace of many serious offences like organized kidnapping, land grabbing, contract killing, extortion, also of many major financial crimes and large bank frauds. This will be a very effective addition in the substantive law. In this regard, the committee recommends that the term used like gang, mafia, crime ring, gang criminality, racketeering, and serious offences may be defined. The term criminal organization. The term criminal organization may also be defined clearly, as it lacks a distinct definition, leaving uncertainty about the criteria for categorizing an organization as criminal and any associate procedure for such classification. So hitherto, it was very difficult to define what do we mean by organized crime. How to define it? There was a difficulty. Now, in order to get out of such a difficult situation, a new section has been introduced in BNS, which was not there in Indian Penal Code, which defines what is an organized crime and how to deal with such offences. This is section 111 of the BNS. This has got 7 subsections. Section 111 subsection 1 says, any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons, illicit goods or services, human trafficking for prostitution, human trafficking for ransom. So this is an inclusive definition. So when we say inclusive definition, some other activity may also be added in the days to come. It doesn't restrict only to this. So criminal or organized crime means the offenses which includes this. How? By any person or group of persons, either acting in concert, either singly or jointly. So a group of persons may together commit this particular offense, or a group of persons forming a syndicate. Among them, any one person can commit the act for and on behalf of the organized crime, criminal activity. That can be categorized as organized crime. Mundak Nodi, either as a member of an organized crime syndicate. So even a particular member of an organized crime syndicate, if he commits that particular offense, it becomes an organized crime. Or on behalf of such syndicate, by use of violence, ingredients, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit. So the object is to obtain material benefit, either directly or indirectly. And in order to reach that object, violence has to be committed, or there should be a threat of committing violence, or there should be an intimidation, that is threatening, or coercion, that is using force, or by any other unlawful means in order to obtain the material benefit. So any of these offences coming under this A to N, clause A to clause N of subsection 1 of section 111 amounts to an organized crime. Now, in the same section, certain words and phrases used therein have been defined. In the form of an explanation, first we will see explanation 2, continuing unlawful activity, because section 111 starts with this phrase, any continuing unlawful activity. So by saying continuing, it would mean that a single act by itself will not become an organized crime. The persons in that syndicate must be habitually doing that particular act. There must be at least minimum two to say it is continuing. There cannot be only one act. So continuing activity means, explanation 2 I am reading, an activity prohibited by law, which is a cognizable offense, punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly, as a member of an organized crime syndicate, or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and the court has taken cognizance of such offense. What are the ingredients of this? The ingredients of this subclause 2 are, number 1, the act that they have done must be prohibited under law. Number 2, it must be a cognizable offense. What do we mean by a cognizable offense? Has been defined in BNSS and CRPC. A cognizable offense is one, of course under CRPC I am talking about, or in BNSS. Cognizable offense is one which has been shown as cognizable in the schedule appended to the Sanhita or the code, where a police officer can arrest a person without a warrant. So it must be a cognizable offense, and the offense must be punishable at least with an imprisonment of 3 years, and such activity must have been undertaken by any person, either singly or jointly, and that person doing that particular act singly or jointly must be as a member of an organized crime syndicate, and in respect of such offenses, there should be more than one charge sheet. That is, the earlier charge sheet must have been filed at least within 10 years prior to the date on which the present charge sheet is filed. And And not only that, the court must have taken cognizance of it. Mere filing of a charge sheet earlier is not sufficient. The court must have taken cognizance of it. So we have to go to CRPC. We have to read section 190 of the CRPC or section 210 of the BNSS to understand what do we mean by taking cognizance. The court must have taken cognizance of it. And it includes the economic offense also. Economic offense means the offense that affects the economy of the nation, exchequer. So that is called as an economic offense or a fiscal offense, we can call it. So these are the ingredients which should be present to constitute an activity as an unlawful activity. And so far as the words kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, contract killing is concerned. Of course, whatever the definition that is found in BNSS for the words which are available here, that can be taken into consideration. And for others, we may have to refer to the law dictionary or some standard dictionary for understanding. But so far as the economic offense is concerned, there is a definition. There is an explanation given by way of explanation 3. What does it say? Explanation 3 says, economic offense includes, once again an inclusive definition, criminal breach of trust, forgery, counterfeiting of currency notes, bank notes, and government stamps, hawala transaction, mass marketing fraud, or running any scheme to defraud several persons, or doing any act in any manner with a view to defraud any bank or financial institution or any other organization for obtaining monetary benefits in any form. All these offenses are economic offenses. There is a familiar word which everybody uses for such companies as blade companies. They offer the public, you deposit 2 lakhs today, you will get back in 1 year of 30% of interest. Nobody can give 30% interest. And we people believe and we deposit money there, and we not only lose the principal but also the interest. So such offenses are covered under this particular explanation 3 to section 111. After all, law is enacted on the basis of the experience that the country has the experience that the country has obtained over a period of time. We have been seeing for the last 10-20 years how the things are happening, how the blade companies have come into existence, how they have cheated the people, looted money, and there was no sufficient provision of law which could handle them effectively. And therefore, this particular section has been brought into statute book according to me, as it has been mentioned in the objectives. Then, with regard to the definition, that is committing an unlawful activity, including kidnapping, economic offenses, cyber crimes, etc. Organized crime syndicate is the word that is used. What is an organized crime syndicate? Organized crime syndicate means, that is defined in explanation 1. Organized syndicate means a group of 2 or more persons who acting either singly or jointly as a syndicate or gang indulge in any continuing unlawful activity. So, in order to constitute an organized syndicate, there must be minimum 2 persons, one more. They must be acting either singly or jointly as a syndicate or as a gang, and they must be indulging in continuing criminal activity. The word syndicate has not been defined. However, when we look to a law dictionary, I have taken the definition from a law dictionary, that is Mitra's Law Dictionary, page number 677, where syndicate means an association or group of persons who combine to carry out on their own account a venture. Combine to carry out on their own account a venture. Again, gang has been defined in the same dictionary at page number 339. Gang means any band or a company of persons who go about together or act in concert. Their purpose is habitually to commit dacoity, which can be proved by their declaration or conduct. So they will go always together in a gang. Their intention is to commit dacoity. In concert, there was one film that Danda, what is it? Dandupalya. Bharatiya picture ಹೆಸರು. That is the best example for this word gang, according to me.
ದಂಡುಪಾಳ್ಯದ ಅಂತಕರು ಸರ್.
Dandupalya, correct. So that film is the best example for this definition of the word, because their intention is only to commit robbery or dacoity. And for that purpose, they adopt all illegal means, unlawful means. Their main purpose is to obtain material benefit either directly or indirectly. Then there is one more. So all the three explanations we have seen. Now, subsection 2. Subsection 2 of section 111 deals with punishment. Whoever commits organized crime shall, if such offence has resulted in death of a person, punishable with an imprisonment for life, and shall also be liable for fine, which shall not be less than 10 lakhs rupees. So minimum fine is 10 lakhs. B. In any other case, that is where death is not caused, punishment with imprisonment for a term, which shall not be less than 5 years, but which may extend up to imprisonment for life, and shall also be liable to fine, which shall not be less than 5 lakhs rupees. Then, now look at the way in which the entire section deals with the organized crime. Whoever abets, attempts, conspires, or knowingly facilitates any commission of an organized crime, or otherwise engages in any act preparatory to an organized crime, shall be punished with an imprisonment for a term which shall not be. So whoever helps a person, abets, or attempts, or conspires, even conspiracy, and knowingly facilitates them to commit an offence, they are also punishable. Then look at subsection 4. Any person who is a member of an organized crime syndicate shall be punished with an imprisonment for a term which shall not be less than 5 years, which may extend to imprisonment for life, and shall also be liable to fine. Then look at 5. Whoever intentionally harbors or conceals any person who has committed an offence of an organized crime shall be punished with an imprisonment for a term which shall not be less than 3 years, and which may extend to imprisonment for life, and shall also be liable to fine. What does it mean? This is applicable to a public, to a person who is not a member of a syndicate and who has not committed the offence. Supposing a member of a public conceals a person who has committed an organized crime, or harbors him, protects him, even that person is punishable under subsection 5 of section 111. But there is a proviso, very interesting proviso. If such person who harbors or conceals is the spouse of the offender, the above subsection shall not apply. What does it mean? If the husband is the perpetrator of the crime, and if the wife conceals him, it is not an offence. That is, it doesn't come under subsection 5. Vice versa. So that is the proviso. Then look at subsection 6. It deals with the property. Whoever possesses any property derived, look at the wordings, please. You are all academicians. You can very well discern it, dissect it. Whoever possesses any property derived or obtained from the commission of an organized crime, or proceeds of any organized crime, or which has been acquired through the organized crime. Look at the definition. Either they must have derived, they must have obtained, or they must have acquired through the organized crime. They are all punishable with an imprisonment. And if any person on behalf of the member of an organized crime syndicate is at any time has been in possession of any movable, immovable property for which he cannot satisfactorily account, shall be punishable with an imprisonment of not less than 3 years. Supposing a person commits an organized crime and he takes away some property belonging to some person while committing an organized crime, victim, and some A comes in possession of that property through some manner, some mode, And that person who has come in possession of that proceeds of the organized crime is also liable for punishment under subsection 7 of section 111. That is the seriousness of the offense. And if you go to BNSS, Bharatiya Nyaya Sanhita, if I am correct, it is section 107, which provides, which is a new section added in BNSS, which provides how to deal with such money when the police or the law enforcing agency during the course of investigation seizes such money or seizes such property, which is the proceeds of the organized crime. How to deal with it has been in detail discussed in CRPC. That is, I believe it is section 107. Just 1 minute, I will make it clear now itself. Section 107, correct. Attachment, forfeiture, or restoration of property. I don't want to deal with that because that particular section itself has got 8 subsections. A very wonderful section it is. So this is how an organized crime has been defined under the BNS, and this is how the various wordings or phrases which are employed in section 111 subsection 1 has been discussed in detail. And this is how the punishment is also prescribed. And this is how the mode of the other persons who are not the parties to the commission of the crime from the public are also made punishable under this particular section. So this is so far as organized crime is concerned. Then coming to petty organized crime. Sir, time aita athwa sir?
Sir, you can take another 5 to 10 minutes maximum, sir. We can conclude then, right?
Okay, sir. Okay. Petty organized crime has been explained or defined in section 112. Whoever being a member of a group or a gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling public examination question papers, or any other criminal act is said to have committed a petty organized crime. So, in order to constitute an offense under section 112, being a member of a group or a gang, a person must have either on his own or joining with another must have committed theft or snatching, cheating, unauthorized selling of tickets, unauthorized betting and gambling, selling public examination question papers, or any other criminal act is said to have petty organized crime. By looking at these definitions, should we not think that the parliamentarians have taken note of the way or the nature in which in the recent past or in recent times the offences are being committed? All these type of offences were left undefined under the criminal law, under the earlier penal law. For example, selling of examination question papers, snatching, unauthorized betting and gambling, all those things were left undefined under the Indian Penal Code, and now they have been brought under a particular section and they have been labeled as petty organized crime. And look at this. they have mentioned the word theft. No doubt, theft is already there in IPC. Section 378 of the Indian Penal Code, the relevant section is found in BNSS also. Theft has been defined as any person who moves any movable property from the possession of another without his consent and with a dishonest intention of making profit, making gain, is said to have committed theft. And that is punishable with an imprisonment which will be up to 3 years and or fine under section 379. But here, theft has been given a different definition. That has been defined. Theft has been explained to include trick theft, T-R-I-C-K, trick theft, or theft from a vehicle, dwelling house, business premises, cargo theft, theft through card skimming, ATM card skimming, shoplifting, and theft of automated teller machines, ATM machines. All these have been brought under this definition of petty organized crime. And such person is punishable with an imprisonment which shall not be less than 1 year. Whereas in section 379, there was no minimum punishment. Even the court can, in appropriate cases, impose fine instead of sentencing him to any term of imprisonment. And in appropriate cases, even court could have exercised this power under section 3 of the Probation of Offenders Act and could have released him after admonition. Or exercised the power under section 4 of the PO Act and released him after taking a bond for undertaking to for a bond of good behavior. But here it is not like that. There is a minimum punishment that is prescribed. No question of PO Act here. When minimum punishment is prescribed, no question of PO Act. So minimum, he is punishable with 1 year of imprisonment, which may extend up to 7 years of imprisonment. So this is called as petty organized crime. I do not want to go discuss with the Terrorist Act because most of the sections in the Terrorist Act are almost similar to organized crime. So therefore, I don't want to discuss about it because of the paucity of time. Then I will discuss about only other two important aspects which, if principal permits me. Agboda?
Yes, sir. Please, sir. Please, sir.
Yes.
Go ahead. Yes.
Snatching.
Right.
We have been seeing since from very long period as to how the offense of snatching takes place. A lonely woman going in the early hours of the morning to a milk booth, purchasing milk and coming on her way back to the house. Some fellow, some miscreant comes from the back, snatches the chain and goes away. Or if some person comes on a motor vehicle, forcibly takes it away and goes. Not only that she will be losing the ornament, but also she will suffer severe injury. All those things will happen. But that particular act of snatching was not covered separately under the Indian Penal Code. So it was after all coming under the definition of 378 or 379 only. Now, section 304 of the BNS has given a separate, called a separate act itself as an offense, that is snatching. They define theft is snatching when in order to commit the same, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away any movable property from any person from his possession. Look at the definition. Theft is snatching, no doubt, because theft takes place when a person moves a movable property from the possession of another without the consent of that person. So here also, when snatching takes place, it is without the consent of the person from whose possession it has been snatched. And how it happens? Suddenly, quickly, forcibly, seizes or secures. All these amounts to snatching. And that is punishable with an imprisonment up to 3 years and shall also be liable to fine. Then there is one section, section 152 of the BNS, which has been newly introduced, because we know that sedition has been held unconstitutional by the Honorable Supreme Court and it has been removed from the statute book. And now there is another section that is a Desha Droha against the government. Sedition was against Rajadroha. Now it is Deshadroha. It is covered under section 152 of the BNS. It is a new section that has been added, which reads as under: Act endangering sovereignty, unity, and integrity of India. This comes under Chapter 7 of Offences Against the State. Whoever purposely or knowingly by words or either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise. Look at the vastness of the section. It has not left any other mode untouched. All modes have been included here. Otherwise, excites, attempts to excite, secession or armed rebellion, subversive activities, or encourages the feeling of separatist activity, or endangers sovereignty, or unity and integrity of India, or indulges in, or commits any such act, shall be punishable with an imprisonment for life, or with an imprisonment which may extend to 7 years, and shall also be liable to fine. So all these acts which are committed against the government, against the state, for that purpose, a person who is committing an offense will excite the people, or attempt to excite the people, or does something against the government, and all these acts are brought within this particular section 152, which can be called as Deshadroha. Of course, there are a number of other sections also. There were sections in Indian Penal Code also, but they were not on these lines. They were something like hate crimes. Hate crimes. But now this section 152 has made it more explicit and self-contained section according to my limited knowledge. So these are the sections which we can cover for the day, I hope, because it's already 6:50. I have crossed the limit which Principal Sir has given to me. I'm sorry.
Thank you, sir.
Thank you, madam.
Thank you, sir, for an enlightening and engaging session on Bharatiya Nyaya Sanhita. Your insights and
one minute, madam, 1 minute.
yeah.
So, with my limited knowledge and experience and understanding whatever that I have, understood by reading the sections, and on the basis of my experience, I have placed it before you. You are all academicians. You know how to interpret them better than me. And if you are able to tell me anything more to be added, I will be more happy, and I will, with all open mind, I am ready to receive it and improve upon myself. Thank you very much for providing me this opportunity, both to the Janata Education Society and also the Vivekananda Law College. Thank you very much, sir. Thank you for this opportunity.
Thank you,
sir. Here, your insights and expertise have greatly enriched our understanding of this new enactment. We are grateful for the knowledge you have shared with us, sir. With your permission, can we address the questions posted in the chat box, sir? Our first question comes from Srimati Kalpana ma'am. She asks, are the changes introduced by BNS 2023 timely and helpful in the speedy dispensation of justice, sir?
Speedy dispensation of justice is nothing to do with what has been added in BNSS. Speedy dispensation of justice, according to me, depends more on the procedural code and more on the way in which the human resources work, including advocates, courts, everything, infrastructure, everything. So according to me, this is a substantive law. Indian Penal Code and BNS is a substantive law. It is not a procedural law. So therefore, I do not think that it will have any, better impact on speedy disposal. I can only say that more and more severe crimes have been added here so that it will cover the wider network of the criminal activity in the society.
Thank you, sir. Next, we have a question from Sri Rajeshwara Rao, sir, who says, it's my privilege to participate in the session on BNS. As you said, Chapter 5 of BNS is most important on the offences against women and children. Unfortunately, the persons committed these offences are getting bail and freely moving in the society. In case lower court not giving they go to higher courts getting bail. Is this BNS given any kind of punishment, and it is and take just a minute, sir, and take it as cognizable and non-bailable offense, particularly minor girl rape cases and speedy justice? I seek your valuable remarks, sir. This is the question from Rajeshwara Rao, sir.
According to me, the offences against the children are being dealt very severely by the courts, both at the lower level and also at the higher level. So far as the granting of bail is concerned, the law is very clear that, of course, they are all cognizable offences, no doubt about it, and they are all non-bailable offences, no doubt about it. But merely because they are non-bailable, that does not mean that the bail should not be granted at all. Whether granting bail or not granting bail is at the discretion of the court. So the court will have to use its judicial discretion under the facts and circumstances of each case and decide whether to grant a bail in a particular case or not. There are cases where the bail has not been granted even for months together, even for years together, having regard to the severity of the offence and the gravity of the offence and its impact on the society. Therefore, a uniform standard cannot be placed where in all non-bailable offences bail should not be granted, because the code itself is very clear. Supposing if you read section 437 or 439 of the CRPC equivalent BNSS, which says that court may grant bail. That means it is left to the discretion. Of course, at the lower court level, there are a lot of conditions and restrictions placed in section 437. But under section 439, the district sessions court and high courts have got wide powers.
Thank you, sir. Yes, another question from Srimati Kalpana, ma'am.
And one more thing.
Yeah.
Rejecting a bail should never be should never be treated as should never be as a measure of punishment. Should never be as a measure of punishment.
Okay, sir. The next question is from Srimati Kalpana, ma'am, who asks, is the BNS 2023 an overhaul of IPC or changes of some of the provisions only?
It is, most of the sections are repeated, or reincorporated in the BNS. But there are certain important sections which have been added, including the definition part which I said, which has got a larger impact and a greater significance in the overall working of the criminal jurisprudence, according to me.
Okay, sir. The next question, the last question is from Dr. Sumitra R. Ma'am, who says, sir, thank you for the insightful session on BNS. Sir, kindly let me know where can we find a provision dealing with eve teasing? If it is not included in BNS, how can our legislators turn a blind eye to this menace where the victims can be both girls and boys?
Eve teasing is a part of outraging the modesty of a woman. Eve teasing is if we read the definition of the word outraging the modesty of a woman found in section 354, eve teasing also comes within that particular section only, the meaning. You have got that stacking, you have voyeurism. That is, stacking means following a woman wherever she goes. All those things are included in section 354, especially after this, in this BNS, it has been made more severe.
Okay.
I am not aware of any other special enactment which deals with eve teasing, but according to my limited knowledge, I think section 354 IPC, which is now in BNSS equivalent provisions, with additional provision, it has been more strong.
Okay,
Yes, sir. Yes, sir. It is there in section 79, sir.
Okay.
In BNS, it is there in section 79.
1 minute, sir. 1 minute.
Yes, sir.
Thank you very much, sir. Thank you.
Right. Word, gesture,
Yes, yes,
or act intended to insult.
This is actually section 509 of the Indian Penal Code.
Yes.
Section 504, sorry.
Yes,
Section
sir.
504 of the Indian Penal Code
Yes.
has been brought in the form of section 79.
Yes, sir.
Okay, sir. Thank you, sir, for the detailed answers, and to all the participants for their thoughtful questions. If any of the participants has any questions, you can unmute your mic and ask the queries.
Sir, this is Jagdish Alshetty. Sir.
Yes, sir.
Please,
Yes, sir.
continue.
Sir, may I know your views on retention of marital rape exception in BNS, though there has been demand for its repeal of such exceptions?
Please come back again, sir. I did not catch you.
Sir, your views on retention of marital rape exception in BNS.
Marital
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 rape
Marital
exception.
rape. Marital rape, sir.
Marital rape. Okay.
Marital
Okay.
rape exception
Ah.
in BNS, though there has
Ah.
been a demand for its repeal of such exception.
Marital rape means that is
Husband committing.
non-consensual you are telling about.
Yes. Husband.
Non-consensual.
Yes.
Non-consensual.
Yes.
That is, according to me, it is very difficult to discern in my limited knowledge. No doubt, it is a talk of the day now. But I don't know how I am not able to say anything about it, except that exception 2 to section 375, about which I have already said. I may not be in a position to throw much light on the subject, sir. Sorry.
Because there is
anyway, I will take note of this and also try to find out if I can get more inputs on this subject also, so that I can gain much more knowledge. Thank you for putting this question.
Any questions from the participants?
Nirmala Madam, there is another question on same marital offense.
You can.
Asked by Deepa Manjunath Patil Madam. What is the punishment for extramarital offense? Because there is a contradiction between the personal laws and IPC and unconstitution of adultery.
Adultery has not been fully made unconstitutional, if I am correct. It has been made only partly unconstitutional and not fully. Subject to correction I am talking about, of course.
It is no longer an offense, sir.
But which can still be a ground for divorce.
Divorce.
It is not an offense anymore.
Of course, it could be a ground for divorce. It could be a ground for divorce.
So as it is, we have a law. Consensual sex between two adults is not a crime anymore.
It's not a crime anymore. Correct.
So it can be ground only for the divorce. That's it.
Yes.
It can be
A ground for divorce, sir. That's what the person.
Of course. It could be.
Yes.
It could be.
Right.
Thank you, sir. On behalf of everyone, I would like to express our heartfelt gratitude for taking the time to address all our queries during the session. Your insights were invaluable, and willingness to engage with us truly made a significant impact. Thank you for sharing your expertise and for your thoughtful responses. We look forward to the opportunity to learn from you again in the future, sir. May I now request Dr. Bhuvaneshwari S. Kolaki, Madam, to formally propose the vote of thanks.
Before that, Dr. Bhuvaneshwari, I must inform all the participants that our honorable guest today, Shri Venkatasudarshan sir, is about to, he has to travel to USA today. He has to catch a flight. I think in a few hours from now. In spite of his busy schedule, he has accepted our invitation to discuss this, for which on behalf of my institution, my chairman sir is also here. M.R. Lakshmi Manohar sir. Sir, you have to thank him.
I thank you, sir, in spite of a busy schedule. And I had also come to know that you are to visit your leaving for states. I thank you, sir, for having suggested invaluable observations made on the BNSS. I thank you from the Janata Society and also from Vivekananda College of Law, sir.
So kind of you, sir. So kind of you. So kind of
Sir,
Okay. Go to Bhuvaneshwari.
Allah Kempegowda sir or phone ಮಾಡಿ
Sir.
Kempegowda sir or phone ಮಾಡಿ ಕೇಳಿದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ವಲ್ಲ ಸರ್.
Thank you, sir. We are very much humbled, right, sir.
Shall I, sir?
Yes, ma, please go ahead.
Good evening, respected sir, speaker sir, Dr. Venkatasudarshan sir, former district and session judge, Sri M.R. Lakshmi Manohar sir, chairman governing council, Vivekananda College of Law, Bengaluru, Professor Dr. K.B. Kempegowda sir, principal, and dear participants. It has been a great learning experience listening to a detailed session on an overview of the Bharatiya Nyaya Sanhita 2023. I, on behalf of General Education Society's Vivekananda College of Law, Bengaluru, express wholehearted gratitude to Sri D.R. Venkatasudarshan sir, former district and sessions judge, for your insightful session. Thank you very much, sir. I thank Sri Lakshmi Manohar sir for inaugurating the program. I thank our principal, Professor Dr. K.G. Kempegoda sir, for organizing this program. I also thank all the dear participants for your active participation in this program. Thank you one and all. For the kind information of all the participants, tomorrow's session, that is on August 8th, will be by Professor S.G. Gaudapanavar, KLE Societies Law College, KLE Technical University, Hubballi, on the topic New Offences under the Bharatiya Nyaya Sanhita 2023. Thank you everyone. Thank you everyone for joining us and making the first session very successful. Thank you everyone. Good night.
Thank you, sir.
Thank you.
Thanks
Thank
to
you,
one
sir.
and all.
Happy journey, sir.
A very happy journey,
Sir?
sir. A very happy journey, sir.
Thank you.
A
Thank you
very
very
happy
much.
and a safe journey.
Right, sir.
Thank you. Thank you.
Thank you.
Happy journey. Stay safe.
Thank you very much.
Thank you, sir. Thank
Thank
you very
you.
much, sir. So